Thank you.
The voice of Julie Rikelman from the Center for Reproductive Rights,
about the safe haven laws.
presenting for the Jackson Women's Health Center.
That in all 50
and now a
states,
question from
you
Associate
can
Justice
terminate
Amy
parental
Coney
rights
Barrett.
by relinquishing a child after abortion, and I think the shortest period might have been 48 hours, if I'm remembering the data correctly. So it seems to me, seen in that light, both Roe and Casey emphasized the burdens of parenting. And insofar as you and many of your amici focus on the ways in which the forced parenting, forced motherhood would hinder women's access to the workplace and to equal opportunities. It's also focused on the consequences of parenting and the obligations of motherhood that flow from pregnancy. Why don't the safe haven laws take care of that problem? It seems to me that it focuses the burden much more narrowly. There is, without question, an infringement on bodily autonomy, which we have in other contexts like vaccines. However, it doesn't seem to me to follow that pregnancy and then parenthood are all part of the same burden. And so it seems to me that the choice more focused would be between, say, the ability to get an abortion at 23 weeks or the state requiring the woman to go 15, 16 weeks more and then terminate parental rights at the conclusion. Why didn't you address the safe haven laws, and why don't they matter?
I think they don't matter for a couple of reasons, Your Honor. First, even if some of those laws are new since Casey, the idea that a woman could place a child up for adoption has, of course, been true since Roe. So it's a consideration that the court already had before it when it decided those cases and adhered to the viability line. But in addition, we don't just focus on the burdens of parenting, and neither did Roe and Casey. Instead, pregnancy itself is unique. It imposes unique physical demands and risk on women, and in fact has impact on all of their lives, on their ability to care for other children, other family members, on their ability to work. And in particular, in Mississippi, those risks are alarmingly high. It's 75 times more dangerous to give birth in Mississippi than it is to have a pre-viability abortion, and those risks are disproportionately threatening the lives of women of color.
So are you saying, I mean, actually, as I read Roe and Casey, they don't talk very much about adoption. It's a passing reference that means out of the obligations of parenthood. But as I hear this answer, then are you saying that the right, as you conceive of it, is grounded primarily in the bearing of the child and the carrying of pregnancy, and not so much looking forward into the consequences on professional opportunities and work life and economic burdens?
No, Your Honor. I believe it's both, and that is exactly how Casey talked about it. It talked about the two strands of cases that supported the right. One was the strand of cases supporting bodily integrity, and it cited to cases like Cruzan and Riggins versus Nevada. And the second was the strand of cases supporting decisional autonomy, and specifically decisions related to childbearing, marriage, and procreation, decisions like Griswold, Loving. And so it's really both strands that we're relying on here.
May I ask you a question about stare decisis, counsel? Your colleagues on the other side have emphasized that Casey rejected Roe's